Thanks, Chair. Commissioner Klein, thank you for your article about TikTok. Before I get on to the decision about the investigation, I think it's important that you've made a public observation in your position that what TikTok is doing is, quote, harmful, invasive and corrosive of online privacy. Not exactly a big green tick for them and their practices. And you also rightly note in your article that it is a choice by Australian companies to place this pixel on their website, and that they have important responsibilities too towards their customers. I suspect a lot of Australians would be shocked to know that these sites are passing off their information to companies like TikTok, particularly one beholden to an authoritarian government. I do want to examine, though, this issue of your decision not to proceed to an investigation in your views, in your arguments set out in the article, because it's not unlawful conduct. You observe that a lot of companies engage in this kind of data collection and it's not inconsistent with the law, but the allegations against TikTok are different to the allegations against other social media companies who use these tools, weren't they?
In the inquiries we made, Senator, we didn't find any cause to believe that what TikTok was doing was out of step with other social media platforms.
The article that was published over the summer that you referenced that broke the news is written by a very experienced tech journalist, and it was informed by research apparently conducted on behalf of Civic, which I understand to be a credible company in the data industry. And they both suggested that uniquely TikTok's pixel was scraping the data of website visitors prior to them granting consent, including as they filled out the form before they clicked submit, for example. And they both observed that other similar style tools from other social media companies did not do that. They waited until consent was achieved or the submit button was hit. Did you test that proposition?
I can't speak to the detail of the investigation, Senator, but by its very nature, when we initiate preliminary inquiries, we're doing so on the basis of requesting information from the relevant entities. We're not doing a forensic examination of the technology at hand. So we haven't done that level of analysis in this case.
Well, how did you arrive at the conclusion then it was no different from any other social media company if you haven't done a forensic examination of the practices?
So the way, generally speaking, pixels work, and based on the information we were able to obtain, the collection by the website owner happens at some point of your use of the website, which is governed by the terms and conditions of the use of the website, which most individuals won't read, of course. And we were able to review the contractual terms, both of the websites and the contractual terms that TikTok imposes through its pixel. And I can't speak to the details of that, but that gave us sufficient satisfaction that TikTok had managed through contractual terms the allocation of responsibility when it comes to the Privacy Act in the context of the pixel.
Which websites did you examine their terms?
Apologies, I didn't mean to imply that we were looking at specific websites. We were basing our inquiries on information provided by TikTok. Right.
So we're relying on TikTok's explanation of their practices. Do you think that's a good idea?
I would say our inquiries were motivated initially by the Civic data report and the reporting around that. So we did do other research to ground those inquiries. And I think there's generally a good technical baseline of knowledge in the OAIC which informed those inquiries. The way in which the value chain of pixel data is set up is such that the key entity with the Privacy Act obligations is the website itself, not TikTok. TikTok is a party to whom data is disclosed, and therefore they have certain obligations under the Privacy Act. But on the basis of the material we saw, they are managing those obligations through either compliance or through contractual obligations.
But, I mean, TikTok is a company that's been exposed around the world repeatedly lying about their use of data. I mean, the most infamous example is when they were accused of using data collected on their app to identify the sources of a journalist who was writing critical articles about it in America. Their initial public statement was, not only would we never do that, we're not that sort of company, it's not even technically possible for us to do that on our app. They subsequently had to admit that was not true, that employees in the business had done exactly that and they fired them as a result. So why would you rely on TikTok's assurances alone to determine whether you're going to proceed to an investigation?
Senator, while I share your concerns, we have to use our resources and our powers in a proportionate way, and we do that through staging and a process of inquiry that begins with initial inquiries, which then would need to reach a certain threshold for us to open investigation. Once we do that, would need to meet a certain threshold for us to issue a determination or seek civil penalties, and we have to do it in that way. And in this case, managing all factors, and given the size of the organisation and the unfavourable legislative framework that we think we're working within, that was the strategic decision we made.
I'll come to that legislative framework in a second. I think that's an important thing to explore. You mentioned a moment ago that you did other research. Did you engage with Civic Data as part of this process?
We have engaged with them, yes, in an informal way. And indeed, I received their feedback on the article yesterday.
When did you first engage with Civic Data?
I personally engaged with them some weeks ago in an informal sense. I would have to come back to you in terms of the office because the work predates my time as privacy
Right.
commissioner.
I mean, as I understand it, you wrote to TikTok in January. Why would it only be a few weeks ago that you approached Civic Data? They're the ones who blew the whistle on this practice and had information about it.
Apologies, I don't want to give you the impression I approached them. I met them in the course of my work, but I didn't formally engage them. I'll have to take on notice whether the team formally engaged them as part of the inquiries that they opened in January, which was before my tenure.
Right. And when either you or your team engaged with them, what did you ask them for? Or what did they provide to you?
Again, I spoke to them in general terms about pixels as part of my efforts to maintain an up-to-date understanding of the ecosystem. I also
right, so it wasn't part of the inquiry?
No, I didn't. I hope I didn't give you that impression. I
did have that impression. You did qualify it by saying it was informal, but I didn't understood what you meant by that. So were they formally engaged as a part of this process at all?
I don't know.
Doesn't sound like it.
I'd have to come back to you on that, Senator.
Okay. I mean, this doesn't exactly... I'm not getting the impression that this was a really thorough exercise in determining whether... You've primarily relied on TikTok. You haven't checked the websites. It doesn't sound like you've engaged with the people who blew the whistle, and you're not actually clear whether or not TikTok was doing something different to other platforms, which is a central allegation.
Stepping back, Senator, I think my office and I understand very well the technological ecosystem that these companies are operating in, and we understand how pixels work, we understand how similar technologies work. We know them to be industry practice. The scope for additional potentially unlawful use by TikTok, as you suggest, in a way that they're kind of blatantly lying in relation to our statutory inquiries with them. I can't speculate on that, but within the context of everything we understand about how these technologies operate, putting together that with TikTok's responses and what we're able to view in that regard, that led us to a conclusion that it wasn't worth pursuing an investigation at this stage.
You said in response to a previous question on notice that I lodged that TikTok provided 2 tranches of information on the 16th and 23rd of February. Did they provide any other material except for those 2 occasions?
I don't believe so.
Okay. Is there any reason why you couldn't make that information available to this committee?
I would have to take that on notice. I don't know what the office's practice has been and the circumstances in which information is obtained via preliminary inquiries. I do know that there is some commercial in confidence information that has been shared that we wouldn't be able to share further. But
this committee and the Parliament does not accept commercial in confidence as a valid reason for not answering a question. The only valid reasons are set out in the public community interest claims, which you could make if you feel you need to, but commercial in confidence is not an accepted grounds.
Well, and Senator Patterson, I think the Commission has taken that on notice so she can understand if there are any grounds or if she can provide it to you.
Thank you.
I think she's undertaken to do that.
Thanks, Chair. I have just one final question on this matter. You mentioned legislative change is necessary to address this issue. I don't think there'd be a lot of people who would disagree with that. What is the most direct legislative means to address this in your view?
I believe that a series of changes are necessary across the kind of information value chain in order to bring really harmful privacy practices under control. For example, we haven't spoken much about children and children's data, but that is an area wholly unregulated under the Australian Privacy Act. And there is a lot in terms of a children's online privacy code, for example, that could start to create incentives for platforms to deliver better products to children and disincentivise the collection of data through pixels. But in this particular case, I would draw your attention to the fair and reasonable test, which would prevent entities from consenting out of obligations to ensure that their practices on the whole are fair and reasonable, and allow us to take a holistic view of these kinds of practices.
I did say that was the final question, but with your indulgence, Chair, just one other final question. If it was proven that TikTok was in partnership with these websites uniquely harvesting data before consent was obtained, before people click submit on forms and other things, would that change your view about proceeding to investigation?
Just to clarify, Senator, in most cases, consent is not required for those websites to collect data and via Pixel or to share it with TikTok. It's not consent that grounds the legal basis for that data. It's actually just notice that occurs through privacy policies and terms and conditions. So it may not be materially different that we're in the process of using a website that the data is collected, because the entire process doesn't hinge on the clicking or unclicking of a particular box. In most cases, there are some cases in which consent is required for the disclosure, and that relates to sensitive information. And that is an area we're going to look further into, because it may be that information that relates to websites, for example, that collect health data, there may be an area of non-compliance there on the part of the website operators themselves, and that's an area we're going to be scoping out further.
Okay, thank you, Commissioner. Thank you.